terms of the definition of employer, employee, independent contractor, and joint employer, all of which really fit together, we're watching several pieces of key litigation and legislation. In the DC Circuit, we are waiting for the court's decision in the Browning-Ferris case. Browning-Ferris was the NLRB case that significantly broadened the definition of joint employer, loosened the test, said that indirect control and having the control or the right to control but never exercising it could create a joint employer relationship. At the NLRB, we are watching the McDonald's litigation, which is really focusing on the question of whether the franchisor and the franchisees are joint employers for purposes of the National Labor Relations Act and everything that that means. It has tremendous significance, particularly as we evolve into the gig economy, as so many types of work relationships change. The implication would be that many workers who have been classified and treated as independent contractors and not as employees could be found to be employees that would have a number of important impacts. Certainly the application of overtime provisions, for example, in the Fair Labor Standards Act, their qualification and right to benefits as employees as opposed to non-employees. Under the National Labor Relations Act, if they are employees and not independent contractors, they would have the right to union representation and to protected activity as defined under the Act. For the last 8 years under the Obama administration, we saw a movement towards quote, economic reality. The goal of the DOL, and I think the goal of many at the NLRB, was to essentially find that if they could, anybody who was working for someone doing work and being paid should be treated as an employee and should have the statutory and other rights of employees. The courts have been somewhat suspect in terms of the administrative agency's expansion of those rights. And in Congress, we're seeing a number of things. Interesting piece of legislation was introduced in the House, known as the Save Local Business Act. The Save Local Business Act would amend the National Labor Relations Act and the Fair Labor Standards Act. It would amend both acts by adding a definition and test for joint employer, something that has not existed in either statute until now. The test in the legislation would make it much harder to establish that two employers are joint employers, and I think we'll continue to see movement in that direction.